In today's video, I'm going to discuss the new earnings threshold for 2022 and how that impacts on the rights and the entitlements from the Basic Conditions of Employment Act, the Labor Relations Act, and the Employment Equity Act. So stay tuned for that. Welcome back, or just welcome if you're new here. I'm Carmen Free. I'm an employment relations practitioner and I'm also the director of Free Employment Relations. I've included a list of my credentials in the description box below to give you some peace of mind around the content that I share. Two quick disclaimers before I get into the heart of today's video. The first one is my usual disclaimer, and that is that I share a lot of information in these videos, but I'm not able to cover every single exception to the rule, and therefore these videos are for educational purposes only. Please contact a professional if you need to. The second disclaimer is specific to this video. I'm going to be speaking about provisions of the Basic Conditions of Employment Act, the Labor Relations Act, and the Employment Equity Act, as it is stated in those acts. If your industry or your job is governed by sectoral determination or a bargaining council that has a main agreement that alters the terms and conditions slightly, you can still watch this video, but then just take that information and compare it to what is stated in your sectoral determination or your collective agreement or main agreement from your bargaining council. The earnings threshold increase. For quite a few years, the earnings threshold did not increase. The last time it was set was in 2014, and it didn't increase at all until 2021. So from 2014 until 2021, the earnings threshold was 205,433 Rand and 30 cents per year. Then in March of 2021, it increased to 211,596 Rand and 30 cents per year. And now it has increased once again. As of March 2022, the new earnings threshold is 224,080 Rand and 48 cents per annum. To determine what is included and what is excluded in the calculation of the earnings threshold, I have put a link in the description box below so that you can look at exactly what is included in that full amount per year. Please note, with the increase in the earnings threshold, that does mean that employees who were earning above the previous thresholds but below 2022's threshold, their terms and conditions will need to change. Later in this video, I'm going to discuss exactly what needs to happen to employees specifically who were earning above the earnings threshold but who are earning below it now. Before I get to that though, I just want to share some general information around the earnings threshold. A lot of people ask me this question, so I'm going to answer it. Where do you find the earnings threshold? And it can be very confusing because if you get a PDF version of the Basic Conditions of Employment and you scan through it, sometimes you're not going to find it in there, which is probably what leads to the confusion of where is it. Now, you won't find it in all of the acts depending on which format they were printed in, because the earnings threshold isn't necessarily published as part of the act. It is published in a government gazette that gets released separately, and that isn't always an easy document to get hold of. So to find the earnings threshold, the internet is your best friend. That being said, it is included if you purchase the Juta Labor Law books. I'm going to show you my Basic Conditions of Employment, but it's from 2017, so don't be confused that it is showing the old earnings threshold. As you can see, it is a footnote at the bottom rather than included in the act itself. Now I'm going to discuss what provisions are applicable to those who earn under the earnings threshold, but those who earn above the earnings threshold are excluded from. Starting with the earnings threshold and the Basic Conditions of Employment Act. There are some provisions in the Basic Conditions of Employment Act that are not applicable to employees who earn over the threshold. Most of them are contained in Chapter 2, but there is one that is contained in a later section. I'm going to detail all of them in this video. I'm not, however, going to discuss the provisions in exact detail or state exactly what each provision says, so therefore I do recommend, if there's one that is very relevant to your situation, to go look it up specifically in the Basic Conditions of Employment Act. The first provision that employees who earn above the earnings threshold are excluded from is Provision 9 of the Basic Conditions of Employment Act, and that refers to ordinary working hours. Broadly speaking, the ordinary hours provision refers to the maximum number of ordinary hours an employee can work, which generally speaking is 45 per week. There are, however, some sectoral determinations and bargaining council agreements that vary this. Off the top of my head, private security is one where the maximum is 48 hours and not 45 hours. It also regulates the maximum number of hours an employee can work on a particular day. It states that an employee who works 5 days a week can work a maximum of 9 ordinary hours each day. An employee who works 6 days a week can work a maximum of 8 hours every day. Now, those who earn above the earnings threshold are not capped at 45 ordinary hours or at 9 or at 8 hours per day. I have been contacted by employees who are very concerned that their hours are not necessarily capped when they earn above the earnings threshold. So there are 2 things that you can take note of if you earn above the earnings threshold and you are concerned about your ordinary hours not being capped. The first one is the legislation provides the minimums or the maximums, but it does give you space to negotiate with your employer. And the assumption is that employees who earn above the earnings threshold have the capacity to negotiate terms and conditions with their employer that are suitable for both parties. The second thing is that although those earning over the threshold are excluded from provision 9 of the basic conditions of employment, they are not excluded from provision 7 of the basic conditions of employment. And this, broadly speaking, again, refers to the consideration of health and safety as well as an employee's family responsibilities when determining the hours of work. The second provision that employees earning over the threshold are excluded from in the Basic Conditions of Employment Act is provision 10, and this is very closely related to provision 9. Provision 10 is overtime. So because employees earning over the threshold are excluded from the cap of ordinary hours, it does make sense that they are also then excluded from the provisions relating to overtime, since overtime is the payment given to employees for the hours that they work up and above their ordinary working hours. That does mean that the legislation does not require an employer to pay an employee for any additional hours that they put in up and above their usual hours of work if they earn above the earnings threshold. But that doesn't mean that employees who earn above the earnings threshold never get paid overtime. Overtime for employees who earn above the earnings threshold is at the discretion of the employer and as per the negotiations that take place between the employer and the employee. But for employees earning under the earnings threshold, their hours of work, that is overtime, must be paid at 1.5. There are exceptions to this where you can grant paid overtime, and I have made videos about overtime and I've linked those videos down below. The next one also makes sense because employees earning over the threshold are excluded from ordinary hours of work and overtime. They are also excluded from what is referred to as a compressed working week. A compressed working week is exactly what it sounds like. It takes the working week, which might usually be 5 or 6 days, and it compresses them so an employee works more hours on less days in a week. And this can only be done by agreement, but this section is not applicable to employees who earn over the threshold. So employees who work over the threshold can just be required to work a compressed working week without there being a written agreement for them to do so. Moving on to the next provision, which is provision 12. And again, it also makes sense that employees who earn above the earnings threshold, because they're excluded from all the previous ones, that they're also excluded from this one. Provision 12 is averaging of hours of work. This provision speaks about how the overtime and ordinary hours can be averaged over a period of time, and it is very beneficial for employees or employers who work varying hours every week. This is a nice provision to average out those ordinary hours and the overtime hours. However, employees who earn above the threshold, because they are not capped at specific ordinary hours and because they are not necessarily paid extra for overtime hours, it makes sense that they are then excluded from the provision that averages those hours. Closely related to the previous ones, but not exactly the same, employees who earn above the earnings threshold are excluded from provision 14, which refers to meal intervals. So therefore, the legislation does not govern how an employee earning above the earnings threshold takes their lunch break, or if they get a lunch break or a meal interval or a tea break or any kind of break throughout their working day. For example, for employees earning below the earnings threshold, there are specific provisions that refer to when and how the meal interval needs to be paid. Whereas for an employee earning above the earnings threshold, if their employer grants it to them, it will simply be by their negotiations or what was determined at the start of their working relationship, so what was determined in the contract or by verbal agreement or by the behaviors of the party. How will an employee earning above the earnings threshold take their breaks, if they get any breaks, and will they be paid for that time or not? Now, I just want to come in here to say that just because I'm saying that employees who earn above the earnings threshold are excluded from these provisions doesn't mean that they don't get meal intervals. It simply means that the legislation is not forcing an employer to give a specific meal interval in a specific way. The belief is that if you earn above the earnings threshold, that you have the negotiation power to negotiate with the employer the terms and conditions that are suitable to both parties. And of course, an employer does need to take into consideration health and safety considerations, as well as family responsibilities. The next one is provision 15, and this refers to the daily and weekly rest periods. It might be clear to you from what I've shared thus far how complex the labor legislation is when it comes to determining the working hours of employees and making sure that an employer and an employee sticks within the requirements if an employee earns below the earnings threshold. So not surprisingly for me, several of my consultations that I have per week is to soundboard with employers around how to meet the requirements of their business, make sure that the operations of the business run smoothly, but within the boundaries of the legislation for employees who earn below the earnings threshold. Daily and weekly rest periods is exactly what it sounds. It specifies the period that an employee has to rest within a day or a week. This needs to be taken together with the maximum number of ordinary hours, as well as the maximum number of overtime hours that is worked on a specific day or a specific week, and then also factor in the meal intervals and the rest periods, daily and weekly rest periods. A comparison: generally speaking, an employee who earns below the earnings threshold cannot be required to work 7 days a week. However, there is an exception to this by written agreement. It can be done over a 2-week period, but if there's no written agreement, an employee under the earnings threshold cannot be required to work 7 days a week. An employee earning over the earnings threshold without any agreement can be required to work 7 days a week. The consideration that I would like to mention here, however, just because the legislation doesn't specifically prohibit it, doesn't mean it's necessarily always allowed. There will be other factors to consider. So for example, the contract of employment between the employer and the employee for the employee who earns above the earnings threshold. And even aside from the contract of employment, we have to determine whether that instruction is reasonable or does it unilaterally alter the terms and conditions of employment. So there are considerations around that, which is why I put my disclaimers in at the beginning of the video, because I cannot cover every single exception to the rule in this video. But generally speaking, the rest periods that are taken by employees who earn above the earnings threshold come about through negotiation with the employer, and the legislation doesn't specifically say how much rest they need to get every day or every week. Moving on to provision 16, and that is paying for work done on Sundays. Employees who earn over the threshold are not entitled to be paid an extra amount for any work done on a Sunday, unless of course their employer feels like paying them that extra amount on a Sunday, because like I'm saying, this is the legislation minimum or maximum, and then an employer can decide at their discretion. But strictly speaking, an employee who earns above the earnings threshold is not entitled to the specific Sunday pay referred to in the Basic Conditions of Employment Act. On to provision 17. Employees who earn above the earnings threshold are excluded from some of the provisions for night work. Night work is generally considered as work that is done after 6 p.m. at night and before 6 o'clock in the morning. But remember, please check your sectoral determination or your bargaining council agreement, because an exception to this rule, for example, is wholesale and retail, where their night work is 7 p.m. to 7 a.m. But for employees who do not have their night work hours altered in a sectoral determination or a main agreement, the basic conditions of employment defines night work as after 6 p.m. and before 6 a.m. in the morning. Employees who earn above the earnings threshold are excluded from the provisions of night work that refers to an employee needing to get a night shift allowance or some kind of payment for the work that they do at night or the hours of work that they've done after 6 p.m. and before 6 a.m. in the morning, and the provision that states that transportation needs to be available for them to be able to get to work and to leave work. Employees who earn above the earnings threshold, however, are not excluded from the provisions that again take into consideration the health and safety considerations. The health and safety considerations are specifically for employees who regularly work night shifts, because night shift work on a regular basis can have an impact on somebody's health. Therefore, there are specific provisions that refer to that in the basic conditions of employment. The final one for Chapter 2 of the basic conditions of employment is that employees earning over the earnings threshold are excluded from some of the provisions that speak about public holidays. Those who earn above the earnings threshold are specifically excluded from 18.3. This provision refers to receiving payment or how payment will work if an employee works on a public holiday where that public holiday falls on a day that they don't usually work. While employees who earn above the earnings threshold are excluded from the provision that refers to payment for public holidays when that public holiday falls on a day that they would not ordinarily work, they are included in the provisions that refer to how payment for public holidays works when that public holiday falls on a day where they would usually work. So the only difference is included when it is a day that they would usually work, excluded when it's a day where they would not usually work. That is all of these sections in Chapter 2 of the Basic Conditions of Employment that employees who earn above the earnings threshold are excluded from, and employees who earn below the earnings threshold, it is specifically applicable to them. There is one final section in the Basic Conditions of Employment that I'd like to discuss before I move on to the Labor Relations Act and the Employment Equity Act. The final provision in the Basic Conditions of Employment Act only came into the Basic Conditions of Employment Act in 2019, and that is Section 73A of the Basic Conditions of Employment. This specific provision refers to that employees who are alleging that they have not been made a payment that is due to them in terms of the Basic Conditions of Employment Act, their contract of employment, a collective agreement, a sectoral determination, or any of those kind of payments that are due to them, an employee, instead of the other types of routes, can now refer that matter to the CCMA. This, however, is only applicable to employees who earn below the earnings threshold. So employees who earn below the earnings threshold, if they are claiming that an employer has not paid them some kind of remuneration that is due to them, they can refer that matter to the CCMA. Where previously the CCMA did not have jurisdiction to hear cases about payment that was owed to an employee and not made to an employee. If employees who earn above the earnings threshold have an allegation against an employer that they are not being paid what they are entitled to be paid, where they go will depend on what is not being paid and the amount of money that's not being paid, but generally it would go to some kind of a court. So the small claims court or the labor court or the high court, and in some cases to the Department of Labor. The amendment in 2019 made it a lot easier for employees who earn under the earnings threshold to be able to lay claims for money that is due to them because the CCMA is free. And it's also a lot faster than, for example, the labor court. Moving on to the provisions of the Labor Relations Act that are specifically applicable to employees who earn below the earnings threshold and are not applicable to employees who earn above the earnings threshold. Because of the complexity of these provisions, they might need to get videos of their own, so I'm really broadly going to detail the provisions in this video today. Most of the provisions that I'm going to speak of today, if not all of them, only came into effect in 2015. The first one that is only applicable to employees who earn below the earnings threshold is Section 198A. This section speaks of temporary employment services. Temporary employment services are commonly referred to as the use of labor brokers. The legislation picked up that employers were using the services of labor brokers to lessen their burden of compliance with the labor laws. So Section 198 and Section 198A were brought into the Labor Relations Act. Section 198A is only applicable to employees who earn below the earnings threshold, but Section 198 is applicable to all employees. So if you're watching this video and you are employed by a labor broker, or you are watching this video and you're an employer and you use the services of a labor broker, I strongly recommend that you read the provisions of the Labor Relations Act that speaks of temporary employment services. The next provision that is only applicable to employees who earn below the earnings threshold is the one around fixed term contracts. So this is Section 198B of the Labor Relations Act. This provision again was brought in to protect employees from the use of fixed term contract, where fixed term contracts are being used to bypass specific labor law provisions around ending the relationship in a fair way, or how employees should be treated in terms of their terms and conditions. There's a lot to that provision, so I will make a video dedicated entirely to fixed term contracts, but the important thing to be aware of is that for employees earning under the earnings threshold, a fixed term contract or the renewal thereof should be in writing and should be for a justified reason. The Act specifies nine reasons, if I can remember correctly. That's not an exhaustive list. There can be other reasons that are considered fair reasons, but that list does give a very good indication of what will and will not be accepted as a fair reason for a fixed term contract. The last provision of the Labor Relations Act that is only applicable to employees who earn below the earnings threshold specifically refers to part-time employees, and provisions that are only relevant to employees who are part-time employees and earn below the earnings threshold. Again, this was brought in to offer greater protection to employees that are commonly deemed to be vulnerable employees. Moving on to the Employment Equity Act and employees who earn above or below the earnings threshold. There is only one provision in the Employment Equity Act that is only applicable to employees who earn below the earnings threshold. This specific provision refers to if there is a dispute of unfair discrimination. That is, if an employee is alleging that an employer has unfairly discriminated against them based on one of the grounds listed in the Employment Equity Act or any other arbitrary ground. So generally speaking, how that dispute referral will go is if an employee is alleging that there is unfair discrimination, they will first refer it to the CCMA for conciliation. If in conciliation the parties are unable to resolve the dispute, it will then progress to the labor court. As I spoke of earlier in this video, going to the labor court is a very long and very expensive process. The time between when you refer your case to the labor court and when it is heard is rather lengthy, versus when you refer your case to the CCMA and when it is arbitrated at the CCMA. For that reason, a provision was brought in for employees earning under the earnings threshold. If they allege unfair discrimination, they can refer their matter. Remember, I said it goes CCMA for conciliation and then to the labor court. Employees earning under the earnings threshold can refer it to the CCMA for conciliation, and if the dispute is not resolved, back to the CCMA for arbitration instead of to the labor court. This is applicable for all allegations of unfair discrimination except allegations of sexual harassment. Allegations of sexual harassment will still go to the CCMA for conciliation and then go to the labor court. There is another provision that I would just like to say in this video. Another way that unfair discrimination cases can be heard by the CCMA for arbitration is if all of the parties agree to that. So if the employer and the employee agree that they would like the CCMA to arbitrate the matter, and of course if the CCMA agrees to arbitrate the matter, then arbitration will take place at the CCMA and not at the labor court. In absence of an agreement, employees earning over the threshold will go to the CCMA for conciliation and then need to refer their case to the labor court, whereas employees earning under the earnings threshold will go to the CCMA for conciliation and then are able to, if there's no agreement, refer their case for arbitration at the CCMA. Moving on to the final part of this video, and that is what is the impact of somebody who was earning above 2021's earning threshold but earns below 2022's earnings threshold. Employees who fall nicely in that gap of above 2021's earning threshold and below 2022's earning threshold automatically become entitled to the provisions that I mentioned in this video in terms of the basic conditions of employment, the Labor Relations Act, and the Employment Equity Act. This is not at the discretion of the employer. It automatically becomes part of their terms and conditions, and they automatically become entitled to things like the meal interval, overtime, night shift allowance, pay for work on Sundays, and more. My suggestion to employees and to employers who have this situation is to get together and to discuss which way do they want to go about this. The first way is they can implement the new terms and conditions that the employee is entitled to. And the second option is that they can get together and have a conversation and then agree to increase the employee's payment to be above the new earnings threshold instead of changing the terms and conditions. Because if the employee is earning above the earnings threshold, they are not entitled to the provisions that I discussed in this video, and their terms and conditions can remain the same as they were last month. But in absence of that agreement, the employee will just automatically become entitled to the provisions I discussed in this video. I hope that you found this video helpful, and I look forward to bringing you another video next week.